Um, First, I want to say thank you to Brittany and the Down Syndrome Association of Maryland for having me here tonight to talk about healthcare decisions, and it's a really important topic. And I'm sure that you guys do have a lot of questions because it can be very stressful when you're turning 18, your child's turning 18, and what to expect. So here we go. All right, first we have to do my dreaded illegal disclaimer. This presentation is not intended as legal advice. Every situation is definitely unique. And then we do not have a client attorney relationship by having this presentation. And I'm required to provide this disclaimer under the Maryland Rules of Maryland Rules of Professional Conduct. This little wonderful, beautiful little girl in here is my daughter, our youngest daughter, Abigail. She is 27 years, will be 27 years old May 1st, and she is multi-disabled and medically fragile. She requires 24/7 private duty nursing and minute-to-minute care. So I have been through the school system myself as a parent, and I have also transitioned from the school system as a parent as well. So not only is this professionally very rewarding for me, but it's also a passion of mine is to help other families navigate the process. So let's get started. So in Maryland, the age of majority is 18 years of age. That means that when a person turns 18, they are presumed to have a legal capacity to make decisions about their own living. So that's financial, healthcare, legal. And until that presumption is rebutted in a court of law, then those rights attach upon the age of 18 years old. The other thing that is important to remember is that if your child turns 18 and they have the presumption is there and has not been rebutted, then the HIPAA law, which is the federal privacy law for healthcare, is going to be something that's going to pretty much come to the forefront very, very quickly. So HIPAA dictates who has the authority to access a healthcare record and make decision making for personal health information and make decisions regarding health care. The other law that I would like to point out is if your child is going to take any other classes other than high school level classes, then the federal data privacy law for students would come into play. We really don't see that in Maryland until you transition at age 21, and you're still going to go to school. If you are doing a hybrid where you might be taking a class, whether it's an educational class or a swimming class at your community college, and you're taking it for some type of a grade, then the actual FERPA rights transfer at the age of 18 to the student for the community college. But at the same time, if they're still enrolled in the high school age and the secondary education, then it remains with the parent. So we talked about this presumption of being competent at the age of 18. It shows one physician certificate to show that an individual is competent. However, in Maryland, it takes two medical professionals to certify that there is incompetency. One has to be a physician, and that physician would have to normally have the exam of your child. The second would be one of the following: a second physician, a psychiatrist, a psychologist, a nurse practitioner, or a licensed clinical social worker. So what is legal capacity? It's having the mental competence to understand the bounty of your desire. So that's understand the nature, the purpose of it, and the consequences of a particular decision regarding medical or financial, or document that is concerning a financial or medical decision making. So for example, for a document, it would be, does your child have the legal capacity, the mental competence to understand an advance directive and what that means, what it is, and how those decisions within that particular document is the desire of his or her bounty. That's really how the legal capacity interplays with legal documents, but also how it plays with just having the competence to understand the rights of that they have at that age. So what's an advance directive? An advance directive is a legal document that's recognized under Maryland law that explains how an individual wants to be treated if that individual is unable to make medical and end-of-life decisions for themselves. So it's a combination of two documents. The first part is a healthcare power of attorney, and that's really to get us through the HIPAA gate. And then the second part is the living will portion, which is the end-of-life decisions and what that individual would like if they are in a coma, for instance, and there's no hope of coming out of the coma, you're brain dead, in a persistent vegetative state, you have a terminal cancer that's pretty imminent. What do you want your end-of-life decisions to look like? And we'll get into that as we move forward through the presentation. Okay, why is an advance directive important? It's important for a variety of reasons. It removes guesswork out of someone's beliefs and healthcare decisions, particularly when they are incapable at that particular moment to make those decisions for themselves. It defines values, what makes a person's life worth living. It chooses a healthcare agent, which is very important, and it emphasizes that the person selected is an individual who understands the maker of the advance directives values and is willing to speak on their behalf when they aren't able to speak on their behalf, able to speak for themselves, or would want some assistance in speaking for what they really want, and they're for some reason unable to do it at that particular time. There's lots of specific treatments that may come into play, and these different types of treatments would also require some form of a decision. So we're looking at CPR perhaps, or staying on a ventilator, artificial nutrition. Perhaps a feeding tube needs to be inserted. Is there any other type of medical care that the individual who's doing the advance directive wants to have their desires spoken for through the agent would be in this advance directive that would be drafted and signed. We talked about capacity. There's a continuum of capacity. And what does that mean? It means that a person is capable of making a voluntary, independent, and a decision based on knowledge and understanding about whom to select to assist in their own decision making. Then the least restrictive methods should be chosen, and then review from least restrictive to most restrictive. So there is this pandem. Least restrictive, consent on its own, on a person's consent, can consent for themselves. Next, least restrictive is an advance directive. The next least restrictive is surrogate decision-making. The next one is supported decision-making. And then the most restrictive is guardianship. So we'll also be talking about those more restrictive ones as well as the advance directive. All right. Healthcare decision-making with capacity, what does that look like? You can consent, you're able to consent, you are able to withhold consent to your own medical care. You have the ability to employ and discharge healthcare providers. You can discharge, you can transfer the decisions from a healthcare provider to another healthcare provider. So if you decide you don't want to go to one doctor now anymore, then you can change to another doctor. This is all things that happen when you have capacity to make your own healthcare decision making. You can also consent or withhold or withdraw any type of health care that's being suggested, or any life-sustaining procedures. So I share this because I just want to really hone in on what it means to have the capacity, because that's really important when you're making and discussing whether or not your child has the ability to make decisions for themselves. So, advanced directives, what is it? It's a document that appoints agents to act when an individual's unable to make informed decisions on their own. It engages the individual as an adult planning for the future, making meaningful appointments. And it may include specific instructions about the care that the individual does or does not want to receive. Again, it's a two-part document. The first part is the healthcare directive, which basically deals with the HIPAA information. So it's going to be access to medical records. It's going to be access to any type of testing, be able to go and get a copy of a CD. The agent under an advanced directive on the HIPAA side would be able to do that. The other part of the advanced directive is the living will, which is the end of life decision making. Okay. Advanced directives are flexible. They can be changed. And there's two types. One is effective upon the signing. The other is what we call springing, which means you need two doctors to certify that the individual is incapable of making decisions for themselves in order for the document to be valid. I recommend that the document be effective when signed. There are a lot of cases where a person who is very, very sick can't get out to get two doctors to certify, and house calls nowadays are not very, very often. So as a whole, advanced directives really we recommend it be effective when signed and then put in a safe place. So we just talked a little bit about what an advanced directive entails. You've got the healthcare power of attorney. And again, that's appointing someone to make healthcare decisions for you when you cannot be able to do that yourself. It also has provisions in the healthcare portion of the document, whether or not you're an organ donator, and if so, what type of organ donation are you okay with? Transplantation only, transplantation, science, medical research. That is a section of the advanced directive that's important. And then, of course, the living will, which is outlining your wishes for medical care, such as CPR, ventilation, artificial nutrition, hydration, pain management, how long you want to stay on a ventilator, if that's something that you are looking to do, the individual. If not, no ventilation, no artificial nutrition, hydration, just what your wishes are regarding end-of-life decision-making. Right? Been through this. All right. What's the responsibility of a healthcare agent? It's making choices about the medical care for the person you are acting on behalf. So again, do they need perhaps dialysis or blood transfusion? Do they need a feeding tube inserted? Do they need an operation? What medication do they need? Do you need CPR? If they don't want to have CPR, what are their actual wishes? You can review and release medical records of the individual. You can arrange for medical care and treatment. So you can make the decision on their behalf that they would be getting an MRI that's being recommended or a surgery. You also, through an advanced directive, can make decisions on choices on where they are to live. Is that looking like a group home? Is that looking for like a individual who's going to be living in her own apartment with a roommate and supported living? Those type of responsibilities can also be done through a advanced directive. You can make decisions to stop or start the medical treatment, and then, of course, make the end-of-life decisions for the individual that the agent is acting on behalf. Choosing a healthcare agent is very important. First of all, the person needs to be at least 18 years of age and must be competent themselves. They are going to be the individual that's going to make the difficult decisions, and it's often under pressure. It's a person that can speak to the individual's wishes. It's also the person who can be there when they need them and can make the hard decisions at the time that they need to be made. And you should be thinking about your agent who you trust, that you trust them to make those decisions. You also trust them to know your medical information, and a person who's going to ask questions of the medical personnel to make sure that everyone is comfortable with the decision that's being made. All right, that's if you have capacity. Any questions up to this point?
There's a question in the chat. How do the persons helping an individual with DS sign these papers determine if they understand well enough to sign?
It's a great question. In my practice, when parents come to me and say, I think my daughter can sign an advance directive, I require one physician certificate to say that they are competent to make those decisions. I feel it's important that a doctor weigh in on that because I'm a lawyer, I'm not a doctor. Um, and that's and it's also to protect everybody involved, and, the parents, the child. So that's how I do it in my practice. And I would encourage you to have conversations with your doctor to see if your child would be able to sign an advance directive. I have a lot of clients that are Down syndrome, they're high functioning, they can understand, and the doctor has provided that. I have other clients who have Down syndrome who do not meet that standard, and the doctor does not sign off on it. Then you start moving down to the options that we're going to go over next. All right. Okay, so we're now going to switch over to what happens if your child does not have the capacity to make decisions for themselves for healthcare. That's when we start getting into the alternative methods of decision making for healthcare and the least to the most restrictive portions. Okay. So if there's no capacity or diminished capacity to execute legal documents, then there are other type of legal documents and other laws that are here in Maryland that help our community to be able to navigate the HIPAA gate. The first thing I just was talking about was the medical orders for life-sustaining treatment. It's called MOLST for short. This is going to be basically something that you would talk to your doctor about on whether or not there's going to be a do not resuscitate order, or is there going to be the decision making regarding CPR. That's very helpful for when the medics are called, when you call 911 and the medics come. If there is a MOLST, they know exactly what to do. If the MOLST says no resuscitation, they are legally in and cannot do resuscitation. So I'll give you a little example of that. My wonderful mother-in-law fell, broke her hip, and she was 89. And we called the ambulance, and the ambulance came, and she had a MOLST, and the MOLST said, do not resuscitate. It also said no CPR. And while we headed to the hospital, my husband was behind us, and it was his mom, and he called me, why aren't the lights on, Why aren't there lights on? He was very upset. And I said, well, legally, your mom has a MOLST and has said, do not resuscitate and no CPR, so they don't turn on the lights. And that was very upsetting for him to hear, but legally, the medic's hands are tied. So the MOLST is one way that you can share your beliefs, so to speak, regarding the the CPR and the do not resuscitate. The next three areas that we're going to talk about are really for individuals that really do not have capacity to sign legal documents or a diminished capacity. The first one is surrogate decision making. Then the next least restrictive is supported decision making, and the most restrictive is guardianship. All right, just talked about most. All right, surrogate decision making. Under Maryland law, it allows certain people to make healthcare decisions for a person who is incapable of making healthcare decisions for themselves and who has not appointed a healthcare agent, or they have appointed a healthcare agent, but that healthcare agent is unavailable. There's a priority order of who can serve as a surrogate. The first one is a guardian for that individual who is incapable of making decisions if they actually have a guardian. The next is the patient's spouse or domestic partner, then an adult child of the patient, then a parent, then an adult brother or sister, or a friend or other relative of the patient that meets certain requirements that we'll talk about on the next slide. So I find this interesting because parent is down at 4. But oftentimes in our population, parents are the ones that are the individual that's going to be acting as the surrogate. If you have a friend or a other relative of your child who's going to act as the surrogate decision making, there's a few hoops they have to still go through in order to be legally able to make healthcare decisions as a surrogate. First, they have to be competent themselves, and they have to also present an affidavit to the physician that's taking care of your child that your child is a relative or a close friend, and that there are specific facts and circumstances that demonstrate that your child has maintained regular contact with the person and is familiar with your child's activities, health, and personal beliefs. That's what a surrogate decision maker can do if they are a friend or relative. They have to produce an affidavit. The affidavit is created by the friend or the other relative. I've placed here in bold the code section of where the surrogacy law situates in Maryland law. The reason why I've done that is I recommend to my clients who are going to hopefully be able to act under the surrogacy law to go to that citation. You literally just type it into Google, and when it comes up, you hit print, and then you keep it in your car. And the reason why I suggest that is that a lot of times, and a lot of my clients, and this happened to me too, when you go to a larger university type of a hospital, their risk management departments tend to say, if you don't have an advance directive or you don't have a guardianship order, then you cannot act on behalf of your disabled child. Although that's not what Maryland law says, that's what they're doing because of risk management. They've made a business decision to only allow those two ends of the spectrum to be what is acceptable to them as a hospital. But surrogacy law is something that can definitely work here in Maryland. And I have some clients who they've been using the surrogacy law for 40 years. I have clients who literally, before they even turn 18, like myself, hit the buzzsaw wanting to know where their advance directive or guardianship doc order is. So when Abigail was 17 and a half, I took her to GI at Hopkins, and I was told I could not make the decision for her or speak on her behalf with the doctor at that visit because she was 18, which A was incorrect because she was 17 and a half. But regardless, they didn't budge. And finally, I just said, fine, give her the piece of paper. So she did. And then she turned around and gave it to me. It was absolutely ridiculous. But that told me right away that I had a problem, that surrogacy was not going to be an option for my family. The other thing I will say, I've been my a lot of my clients have been reported lately is those individuals turning 18 who are at Hopkins, they are turning off the parents' access to the My Chart for your child. As they get closer to 18. So I just wanted to let you guys know that. Again, you could use until you determine which way you're going to go, what's best for you and your child. You can use the surrogacy, you can print it out and try to argue with them that this is Maryland law, here it is in writing, and you need to turn back the My Chart on. The next least restrictive is supported decision making. Now, supported decision making is rather new here in Maryland. I believe it was put into law in 2023. It enables individuals to communicate, and make the decisions using support from a trusted individual. It's a person-centered, structured framework, and it's used for important decisions. Persons with the disability is the actual decision maker. The individual that is acting as a supported decision maker is supporting but not making the decision. And it gives validity to decisions made in this context. The key here is that the supported decision maker is not making their wishes on top of the individual with disabilities. It's supposed to be the decision maker is there to support the decision that the disabled individual is making and to help get that decision through the medical system. Okay. There's consent. An individual may consent to the presence of another person during medical appointments or to have consent to let them get the information. And this consent can be retained in the medical files, so it's always there. Consent is not as encompassing as an appointment of an agent under an advanced directive or surrogate decision maker, but it may smooth the way in some situations. My advice is to speak with the medical staff that's taking care of your child right before the age of 18 to make sure that you have conversations with them to see if they believe that your child is capable of making medical decisions on her own or his own behalf, or whether they are not, because that's going to be the gatekeeper, whether or not you're looking at, a consent path or an ability not to consent path. And so that's going to be like the toggle is that physician certificate. And then finally, the most restrictive is guardianship of the person. Guardianship is a legal and judicial process, and it is to determine whether an individual has the capacity to make decisions for himself or whether or not that individual does not have the capacity. If they do not have the capacity, then the guardianship is going to proceed, and it is to appoint someone to act as their guardian of the person, to make healthcare decisions for that individual who is incapable of doing so for themselves. And that would also include, Janet, for instance, where that individual would actually live. It
Okay,
creates
thanks.
it creates a long-term relationship with the court. A lot of people don't realize this, but the court is actually the guardian, and the individual who's appointed as the guardian of the person is acting as a fiduciary, as an agent of the court. That's really important to understand because you're going to have to provide annual accountings and annual reports to to the court. And if you think of it that way, it makes sense of why you're making the reports if you're the agent for the actual guardian who is the actual court. In Maryland, there are some rights that are taken away from the individual who has a disability under guardianship. main one is to be able to have the ability to make healthcare decisions for themselves. It's public record on Maryland Case Search. However, if you were to go down to the Circuit Court for Anne Arundel County and ask for the guardianship file for Abigail Solarziski, you are not going to get far because it's only a public record on the case search as a docket and no records like the petition or the certificates that you have to get are in the public record. Those are all shielded, and only the individuals who are a party to the proceedings can get access to copies of what's been filed. And it is expensive compared to the other options to get guardianship, and it is a process. It takes several months to get a guardianship through the process. It requires serving interested persons, and there is definition of who is an interested person. It also requires the appointment from the court of a court-appointed counsel to represent the individual with a disability during the process. And then there is a hearing. And then there's training that's required. That's all online. It's usually a 45-minute orientation and a 45-minute after you are appointed as the guardian. And again, that requirement each year that you file a guardian of the person report with the court coming up to each anniversary. And that report, by the way, is like 8 pages long. It's pretty, you would know a lot of the information off the top of your head, like is your child still in school? If so, where do they go? If not, are they working? If not, what are they doing during the day? What doctors did you have your child see during the reporting period? Is what type of doctor is that person? Did they go to the emergency room? What medication are they on? So things that you will be pretty quick to be able to answer those questions on an annual report.